So today we start with the decoding of arbitration clauses in the contracts. So arbitration is the most, you can say it's a favorite kind of an ADR process that is prevalent in Indian judicial system right now in order to resolve the disputes. So all the disputes do not go to arbitration basically. Only commercial dispute that are between individuals or corporates, they that affects the individuals in general, they go to uh, arbitration to be adjudicated through arbitration. Or something which is like disputes related to sales of goods act can go to arbitration, but disputes relating to public nuisance and all that cannot go to arbitration. So even in the government contracts also there are arbitration clauses. So what causes how to start with the arbitration process? So main genesis to start is the arbitration agreement. So now we will be discussing about the arbitration agreement, how we draft an arbitration agreement, and how we go to the how we invoke the adjudication of arbitrator and the process of arbitration. So firstly, I will just tell you in brief what all uh, can go into arbitration, what kind of disputes can go into arbitration, and what disputes cannot go into arbitration. As I said, it's only commercial disputes or contracts and all that can go into arbitration. So, in case of matrimonial matters, all the matrimonial matters cannot go into arbitration. Only in case of a settlement, if we are arriving at any kind of a settlement between both the parties, that can go into arbitration. Any kind of a criminal disputes or criminal matter cannot go into arbitration. Any kind of a trust matter cannot go into arbitration. Probate matters cannot go into arbitration. These slides are there. I have already briefly stated all these matters are excluded from arbitration jurisdiction. Like industrial disputes cannot go into arbitration. Special statute have been made for special kind of cases to be resolved. So in that cases, those cases cannot go into arbitration. They have to be tried by that particular tribunal itself. Like insolvency matters, all the NCLT matters, all the winding up and all these matters go into NCLT and NCLAT only. Trust and charitable matters, they don't go into arbitration. So these are the lists where we have to stay away from the arbitration. We cannot invoke the arbitration procedure in these matters. So what does the Act says? The Arbitration and Conciliation Act. What does the Act say? What is an arbitration agreement? How do we start with the arbitration agreement? Now, Section 7 of the Arbitration and Conciliation Act specifically mentions about an arbitration agreement. So what is an arbitration agreement? In this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of defined legal relationship, whether contractual or not. So it says it's in a defined legal relationship, whether contractual or not. Contractual means we go by the main contract act, there is a offer acceptance agreement and there is a consideration. So what is non-contractual things, contractual or not? So non-contractual thing is like in case of rent matters, lease and license matters. Those are not contractual, but they can also go to an arbitration. Their disputes can also be tried through arbitration procedure. So what does Section 7.2 says? An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. You can form it as a part of the main contract as an arbitration clause saying that any dispute, or you can choose the disputes that in that main contract, the commercial contract, that these disputes can be tried through an arbitration as per the Arbitration and Conciliation Act. You can frame that in one contract, the main contract itself, or you can make it as a different arbitration agreement, wherein you will refer to the main contract and say the disputes pertaining to these commercial things can be tried through an arbitration agreement. You can have two separate agreement, or you can have one agreement wherein you can have an arbitration clause. This 7.2 says, so how an arbitration agreement has to be made. So arbitration agreement, first and the foremost thing is that has to be in writing. There can be no oral agreement. Arbitration agreement has to be in writing. It has to be communicated in writing that these disputes has to be tried through an arbitration. There has to be a proper communication in writing. An arbitration agreement is in writing if it contains a document signed by the parties. An arbitration agreement is signed by both the parties, wherein both the parties agree that yes, we will resolve our disputes through arbitration. A simple thing. Or an exchange of letters, telex, telegrams, or other means of telecommunications. Either you can send an email or fax or whatever, but it has to be communicated, which provides a record of the agreement. It has to be documented. You cannot orally say, call up and on a phone, and you cannot say that we want to resolve these disputes through an arbitration. You have to document it. You have to send it through a telegraph, telefax, email, whatever, and there has to be proper communication to it. An exchange of statement of claim and defense in which the existence of the agreement is alleged by one party and not denied by the other party. If I am having a dispute with whomsoever I'm having a commercial contract with, I can send my claim and I will write in that claim that I want to invoke, these are my claims, and I want to invoke the arbitration clause of this agreement to resolve these disputes to an arbitrator. That this means that statements of claims and defense has been exchanged between the parties, wherein we have, I categorically say that I am invoking the arbitration agreement clause. Now, 7.5 says the reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing and the reference is such as to make that arbitration clause part of the contract. You have to make that arbitration clause part of the contract. That is the core issue. Arbitration clause, arbitration agreement has to be made part of the contract. If that clause is part of that contract, very well. If it is not, you have a separate agreement. You have to make that agreement refer to that arbitration agreement. Is that clear? Okay. So how we should write an arbitration agreement should be in writing. This I have already explained. No, the oral communication has nothing to do with arbitration. You cannot invoke the arbitration clause if there is an oral communication. Telefax and telecommunications have already explained. 7.4 states that there has to be exchange of letters, email, telefax, telegrams. 7.5 says the act provides for incorporation of an arbitration clause by reference to another in the other agreement. You have to refer to that arbitration clause. Whenever we go and say that we want to invoke the arbitration, we want to go resolve our disputes through an arbitration, we have to refer to that arbitration clause. That yes, in that contract, we had mentioned that we will resolve these disputes through arbitration. And this is the clause wherein we have agreed upon. Okay. Now, what are the types of arbitration agreement? As I already stated, there are 3 types. Like it can be a clause in the main agreement, which is more prevalent these days. We have a main commercial contract. In that contract, we have a clause. We other clause, like other terms and commercial terms and conditions. We have a force majeure clause. We have a termination clause. We have our other clauses. In that clauses, we have a dispute resolution clause. In that dispute resolution clause, we have this arbitration clause that any dispute arising out of this contract can be resolved through an arbitration. invoking the Arbitration and Conciliation Act or whatever rules you want to invoke. So that clause is mentioned. Like any other clause, these are the basic clauses that is mentioned in the main agreement. Okay. This is very popular these days. This is the clause that is popularly accepted in day-to-day scenario. Now, next is an agreement. We can have a separate commercial agreement and we can have a separate arbitration agreement. Wherein in that arbitration agreement, we refer to that separate commercial agreement saying that any dispute arising out of that commercial contract can be resolved through an arbitration. An arbitration agreement can have all the clauses of an whom do you want to appoint as an arbitrator and what are the qualifications and all that, where you can have your arbitration and what will be the mode of an arbitration. So you can have a separate arbitration agreement and you can have a separate commercial agreement. And this method is generally not followed these days. It was initially followed when there was no difference of separation and separability. Jurisprudence was not defined. Now, what is a separation and separability jurisprudence? Now, these days, recently after 2005-2006 judgments have been passed, wherein there were disputes saying that the main commercial contract is now invalid. So the arbitration contracts also stands invalid and terminated. Now, there are many judgments which says, even if the main commercial contract gets invalid, the dispute resolution clause through arbitration, the arbitration clause is a separate clause altogether and it remains, even if the main agreement is invalid. Is that clear? This is a jurisprudence on the separability clause. So arbitration clause, even if it is in the main agreement, is a separate. It has its own separate entity. It is not being part of the main commercial agreement. Also, has a different separate entity. You can resolve your disputes through an arbitration clause by invoking the arbitration clause, even if the main agreement, by whatever reasons, stands terminated or invalidated. Is that clear? So, and this agreement, having a separate agreement was initially it used to happen. Now it is a part of the main contract after this jurisprudence. Now, third one is by a separate arbitration agreement, which refers to a set of contracts. Now, the parties are same, having different kind of commercial contracts. Like two parties are same, having different contracts, different commercial relationship. So I can have one single agreement, arbitration agreement, wherein I can refer to all the various commercial arrangements and the contracts, and I can say that all these disputes can be resolved through an arbitration agreement. This clause means by a separate arbitration agreement, which refers to a set of contracts. This is also not relevant these days. You can have it, you cannot have it. It depends upon the convenience of the parties. But you can also have one commercial agreement, and have a clause in that agreement saying that the dispute resolution clause, dispute can be resolved through arbitration. Is that clear? Okay. Now, next is how we draft an arbitration clause. What is the mandatory reference to arbitration? First and foremost thing is that you have to mandatory refer, say that you have to refer the disputes to an arbitration. It is very essential to specifically define that any dispute has to be resolved through an arbitration. You just cannot say saying that arbitration, arbitrator, or whatever. You have to clearly define in your clause that you will resolve all your disputes through a mandatory through an arbitration, invoking the Arbitration and Conciliation Act. You cannot say that all disputes pertaining to the agreement shall be resolved through mediation, arbitration, litigation, or any other mechanism. You cannot vaguely say that. Like if not mediation, then arbitration. If not arbitration, then litigation. You cannot vaguely say that. you have to be very clear that any dispute or whatever dispute you want to refer to has to be resolved through an arbitration. You cannot have multiple mechanisms at the same time vaguely. Now, next is intention to refer to arbitration. What does this mean? Intention, that I want to refer my disputes to an arbitration. We cannot say that any dispute arising of this contract may be referred to an arbitration. No, may is very vague. It doesn't say that yes, it's an intent to refer the matter to an arbitration. You have to be specifically say shall be referred to an arbitration. Is that clear? May becomes very vague. It does not gives an intention that yes, there is an intention to an arbitration process. The scope of arbitration proceeding. It can in this situation, in this case, the situation may arise that contract or professional engagement. In fact, you can exclude certain disputes that you don't want to be decided through an arbitration. You can limit the scope of arbitration proceedings. Like only the commercial matters, like only the payment cases can be referred to an arbitration proceedings. You can limit the scope of arbitration proceeding. You cannot say all disputes arising out of. You can also you can say that any kind of a payment issue arising out of this contract can be referred to an arbitration proceedings. You can limit it. You cannot. It's up to you what you want. It's up to the two people who are having a contractual relationship. It's up to them to decide and come to a consensus what they want to refer to an arbitration proceedings and what they want to exclude from the arbitration proceedings. Like they might not want other relationship to be decided through arbitration proceedings, like delivery of any product or whatever. They do not want any kind of dispute arising, the quality of an issue. They want to exclude that from the arbitration proceedings, and they just want to make the payment issue, dispute arising out of any payment issue, as a scope of arbitration proceedings. So you can have all disputes arising out of this contract can be referred to an arbitration proceedings, or you can say that issues relating to the payment issues relating to the disputes of payment can be referred to an arbitration proceedings. You can limit the scope of the arbitration proceedings. Second is you have to also mention that decide between institutional arbitration and ad hoc arbitration or other applicable arbitration rules. Now, there's a difference between institutional arbitration and ad hoc arbitration. You have to say that the matters has to be resolved through an arbitrator appointed by appointed mutually by both the parties. And the rules, ad hoc means all the rules that the parties, both the parties will make their own rules, and the proceedings are conducted as per their own rules. Okay, like two parties, they want to conduct an ad hoc proceedings, they want to make their own rules pertaining to their arbitration proceedings. That is an ad hoc thing. And institutional is, there are many institutional arbitrations going on in our country, like ICA, that is Indian Council of Arbitration, MCIA, SIAC. So you will specifically mention in your arbitration clause that the arbitration proceedings shall be conducted through the rules of ICA, shall be conducted through the rules of MCIA. If it is silent, then it means that it is an ad hoc institutions. You want to conduct your proceedings on your own, by your own, conducted by your own means. Like you will make your own rules and regulations and you will conduct it the way you want to. If you refer specifically that you want an institutional arbitrations, then you will mention it that it has to be conducted as per ICA rules, MCIA rules, or SIAC rules. Now, India has approximately 35 arbitral institutions, but we still refer to our ad hoc arbitration because we are more comfortable by our own ad hoc means. We choose our own rules and regulations. this is also very important to mention what exactly we want to refer to, what kind of rules we want to refer to. So we have to mention the number of arbitrators. And it has written in our section 10 of the Arbitration Act clearly says that parties are free to determine the number of arbitrators provided such number shall not be even number. It can be sole arbitrator or any 3 or 5 on the mutual consent of both the parties. Now, if we failing the determination referred to in subsection 1, the arbitral tribunal shall consist of a sole arbitrator. If the parties do not arrive at any consensus to the number of arbitrators, then it has to be tried by a tribunal, it has to be tried by a sole arbitrator. Only one arbitrator can conduct the arbitral tribunal. It would be best to include the exact number of arbitrators one wants to in order to avoid pending litigation under Section 11. So if we don't agree to, we invoke the Section 11 proceedings. So in order to avoid the that process of pending litigation, we should come to a proper consensus that yes, we want a sole arbitrator or we want a 3 arbitrators or 5 arbitrators, so that the parties are not in dispute pertaining to this, and then application under Section 11 is not filed. Because it again is a lengthy process of going to the court and getting the orders from the court for an appointment of an arbitrator under Section 11. Now, what are the qualifications of arbitrators? So qualifications, it doesn't exactly mentions what should be a qualification of an arbitrator. The act doesn't mention it, but it is prudent to understand that one who has a knowledge of that particular commercial contract should only be able to conduct those proceedings. Like if there is a construction industry contract or any dispute pertaining to any construction matter, so whoever has this experience of knowledge of construction and infrastructure and all that can only conduct the arbitral tribunal. So one who has a knowledge of oil and gas and all that scientific knowledge, then that person can only be one person who is qualified in that has a knowledge of sound knowledge of those proceedings, those things can only be a arbitrator, can be a qualified arbitrator. That we have to find out and understand. That is why we go to an institutional arbitrators, because they have their own arbitrators having in a different field. So it is better to go in an institutional arbitration, having an institutional arbitration. Language of the arbitration. Language, you have to mention specifically what language you want to have an proceeding in, because if there is a miscommunication, if I speak a different language and the other party speaks a different language, if a witness speaks a different language, evidence is not conducted in a manner in which there is a proper communication, then there will be unnecessary pending issues. So parties have to decide on what language the proceedings has to be conducted, any language that both the parties are comfortable with, so that the proceedings go on smoothly. Now, next and very, very important is seat and venue of the arbitration. You have to specifically mention the seat and venue of the arbitration, that the arbitration shall be conducted at the seat of arbitration shall be New Delhi, conducted in the language English. There's a difference between seat and venue. Seat means the jurisdiction, the law, the court's jurisdiction which court's jurisdiction we want to invoke in case of we want to go and find an application. Seat means that if we say seat, it has to be Delhi, then the courts of Delhi shall have exclusive jurisdiction. Unless otherwise we have exclusively mentioned in a contract that other courts will have jurisdiction. But if we mention seat of the arbitration shall be Delhi, then only Delhi courts shall have jurisdiction to entertain any kind of issues arising out of the contract. Venue is the place where you want to conduct the proceedings. Venue can be at my chamber, venue can be the Google Meet. Venue can change according to the convenience of the parties. But seat is a place where the jurisdiction or the laws of where the jurisdiction of the courts shall be invoked in case of any dispute, any issue arising out of the contract. So there is a stark difference between seat and venue, though there are many cases, judgments having different views in this. Balco case is very famous case wherein seat and venue has been defined clearly, but our courts have different jurisprudence on this issue, seat and venue. So seat is different and venue is different. So if you write seat, that is fair enough. Now, what is a dispute clause? How do you draft a dispute resolution clause in the main agreement? We say any dispute or differences arising from or in connection with this contract. I says is that the scope is limited. If you want to limit the scope, you can limit the scope also. You can exclude certain things, or you can say that only these disputes can be entertained through arbitration. So all disputes, it can be framed according to the convenience, according to what the parties decide. This is a general clause that I have drafted, which is included in most of the contracts. Now, any disputes or differences arising from or in connection with this contract, including the adjudication of its validity, termination, or breach. This covers each and everything of the contract shall be referred to and resolved by arbitration under dash money under ICA rules, or you can just say resolved by arbitration according to the Arbitration and Conciliation in 1996. That means that you are pertaining to only ad hoc institution. Or if you define clearly like ICA, SIAC, this means that you are referring to an institutional rules. This you have to define as per your convenience. Then you write the arbitration shall be conducted by a sole arbitrator, or if you want to write 3 arbitrators, then you say one arbitrator appointed by both the parties and the third arbitrator appointed by the 2 arbitrators on mutual discussion. If not a sole arbitrator, 3 arbitrator or 5 arbitrators, you have to define it accordingly who appoints the arbitrator. If it is a 3 arbitrators, then one arbitrator appointed by both the parties becomes 2, and the 2 arbitrators shall appoint a third arbitrator. That makes it the 3 arbitrators. Or you can say a sole arbitrator, who shall be mutually decided by the parties within 7 days from the date of invocation of the arbitration. Then we say the seat and venue of arbitration shall be whichever place you want to, Delhi. Here, if you the arbitral tribunal may change the venue. See, the arbitral tribunal may change the venue on the basis of convenience if needed. Venue can, if you say Delhi, venue you can go and conduct the proceedings in Bombay as well, in any part of the country, wherever you want to. But if you say seat is Delhi, then only jurisdiction of the courts will have, Delhi courts will have jurisdiction. The venue can change according to the convenience of the parties. The arbitral proceedings shall be conducted in English language, very crisp and clear, whichever language you want to. It has to be clearly written. The courts of dash shall have exclusive jurisdiction. Now, if we have mentioned seat, I have marked it in bold that if a seat is mentioned, then there is no need to mention this. It is ideal to mention the seat. Agar seat, if you have mentioned a seat in your previous line, then don't write this line. It's always advisable to write seat. The contract would be governed by the laws of India as applicable. The award shall be final and binding on the parties. This is the crisp dispute resolution clause, the arbitration clause that we draft in the main commercial contract.